Hi guys, it's Kathy. I hope you're doing well. Seeing her there brings me the whole way back to the prelims when this is what we saw. We saw her fighting over how many hairs on the head we get from OJ. And I think like the defense team wanted to give like 2 or 1, and Marsha and her was saying no, we need 10 from each area. I think the judge ruled that they can have like total of 10 or something. It was real little amount. That was so long ago. It's like at the end of a book when they bring back chapter 1, like they remind you of what happened in chapter 1. That's what we're seeing right now. We're remembering the beginning. Oh, maybe I should go rewatch that. No, absolutely not. Let's check everything. Okay, we're good to go.
Way, you did not collect all the items on August 26th. Some items were collected by another criminalist. Is that correct?
Yes, I directed someone to collect the larger items.
Okay. And on the same sheet that you filled out on August 26th, Ms. Kessler, in the box that says by whom it was collected, when it was an item that you personally collected, did you put your initials down?
Yes, I did.
And for items where you directed another criminalist to do the collection, were his initials put in the box?
That's correct.
And for each and every item that was collected by you and the other criminalist on August 26th, was the time the item was collected filled in?
Yes, I did this a little differently than I normally do because the items weren't collected in numerical order. Often I put in the time I start and the time I finish.
Ms. Kessler,
if I do it in numerical order.
Ms. Kessler, the question is, isn't the fact that when you collected evidence on August 26th, you filled in every single box on the field note?
Well, there's a couple I didn't because it was approximate. As you see down at the bottom, I wasn't sure, so I'm where it says approximate, but I guess you could say
fine.
it's filled in.
But you filled it in?
Yeah.
Okay.
But something there.
To your knowledge, as the person who was ultimately in charge of evaluating the performance of your employees, at any time sat down with Dennis Fung and Andrea Mazzola to take some remedial action so that they would fill out all the boxes when they prepare a crime scene form?
I personally did not know.
Did you direct, as the director of the laboratory, a subordinate of yours to take some remedial action with them?
There's been some further training or updating on the importance of crime scene notes and importance of filling them in even after the fact so that you can remember, because frankly I have a terrible memory, so that's why I do it.
Was this a just generalized training program for everyone in the laboratory, or was this a remedial action that was taken in direct response to what Andrea Mazzola and Dennis Fung did or did not do in this case?
It was for everyone.
It had nothing to do with taking remedial action for what Andrea Mazzola and Dennis Fung may have failed to do in this case?
No, because we've been doing a lot of small corrections, if you will, by the supervisors, so we decided to have an updated training, which is an ongoing program we have.
Now, have you did you review the property reports that were prepared by Dennis Fung in connection with this case?
I can't remember if I reviewed all of his property reports or some of them. We've looked at them off and on for item numbers, and I don't remember if I've seen all of them.
Now, it is required both by your office and also by the Los Angeles Police Department manual that the property reports be filled out accurately and completely. Is that correct?
Accurately and completely, depending on certain things require different completeness. A lot of it is narrative, and so, what does complete mean? It's an interpretive issue.
Let me show you People's 187, which is actually in evidence. Let you take a look at it for a moment. 187 of the property reports, the official property reports, filled out for items 1 through 14 in this case, which would be items taken at Rockingham. Could you take a look at that?
Yes.
Now, and I believe you said a moment ago that it's required that these reports be filled out accurately and completely. Is that right?
Yes.
Was any remedial action taken with Dennis Fung for his using the incorrect dates repeatedly in this report?
Incorrect dates?
Well,
Sustained.
let me ask you this. Do you see where it says what date these property items were taken into custody?
Oh, I hadn't even noticed that before.
You see where it says they were taken into custody on June 12, 1994?
Yes.
That's not correct, is it?
I don't think so. It's June 13th, right?
Okay. And in fact, on page 3, take a look at page 3, would you? There, Dennis Fung wrote that all these items were collected on June 14th, didn't he?
Oh, yes, he did.
And that's wrong too, correct?
That's,
Sustained.
It's in evidence.
No, asking the question, that is in evidence. Whether or not she knows what date Dennis Fung collected certain items of evidence, that hasn't established foundationally with this
Oh, I'm
witness.
sorry. Are you aware that Dennis Fung collected items of evidence at Rockingham on June 13th, 1994?
as I recall, if that he did the Rockingham scene on the same day that he did Bundy, then that would be June 13th, if I recall correctly.
So as you look at those official property reports, those dates of June 12th and June 14th are both incorrect. Is that right?
That's correct.
In fact, the property reports, if you look at the front page, don't even say when the items were booked, do they?
That is in a computerized system, so I wouldn't worry that it's on this piece of paper, actually. This is becoming an obsolete form as we speak.
Well, was it an obsolete form when it was filled out in this case?
Yeah, the computer system was in place then, yes. So
There
it
was no
automa-
requirement?
Wait,
I'm sorry.
wait. Let her
I'm
finish
sorry.
her answer.
So that would not be a critical issue as to fill in that date, because that date is in the computer the minute the stuff is entered into evidence, so.
Isn't it required in the Los Angeles Police Department manual that these written property reports be filled out accurately and completely?
I don't recall if it's stated explicitly that way.
Okay, let me just show you.
It's appropriate to fill out these forms accurately and completely.
No, I don't.
All right.
Thank you. And in
Thank you, Your
fact,
Honor.
on the same form, Ms. Kessler, on the same form, you're supposed to put down for the item Cs, the quantity of an item Cs. Is that correct?
Yes, if it's possible.
Well, Ms. Kessler, for the bloodstains that were collected, is there any indication on that property report the number of swatches for any of the bloodstains collected at Rockingham?
No, it just says cloth swatch.
Singular, is that correct?
Yes.
Okay. And the quantity boxes were not filled out, were they?
Well, this is a poor copy. I'm assuming no, but a lot of it's obliterated. So,
Ms. Kessler, do you see anywhere on those reports that anybody wrote in the number of swatches collected for any of the bloodstains?
well, on the very first item, there's one cloth swatch.
Okay.
Yeah, it's filled in.
For number one?
Yeah.
That's the item taken from the automobile. Is that right? Can you have the next one?
Yes, that's correct.
But for items 4, 5, 6, 7, 8, 12, and 14, isn't it correct that they don't say how many swatches were collected for any of those items?
4, and 5.
4, 5, 6, 7, 8, 12, and 14, all the remaining bloodstains.
They're all singular.
Doesn't say anything about the number of swatches, correct?
Well, it doesn't say in the quantity column, it doesn't put anything, but it says cloth swatch, so that indicates singular.
Now I'll simply show you also for People's 188 in evidence, the property reports, which includes the drops on the Bundy walkway. Isn't it true that for items 47, 48, 49, 50, and 52, again, under the word quantity, the quantity was never filled in as the number of swatches collected.
Where'd you start?
47,
That's correct. Again, it says cloth swatch indicating singular.
My question is, has any remedial action been taken with respect to Dennis Fung's failure to note on the property reports the quantity of swatches collected for each of these bloodstains?
The issue is whether, well, he has two options. He can either, so I want to paraphrase something before I answer your question.
I would ask, Your Honor, that you ask the witness to at least respond to the question, which was any remedial action taken?
Answer the question, please.
I can't answer it yes or no
I have to
because
check it out.
he doesn't have to count the swatches,
That's your
depending on how he does it. So,
So your position doesn't have to count the swatches?
no, that's not, you're misstating what I'm saying. There are two ways to book bloodstains. You can either count the swatches, or you can say a
Thanks,
red stain
ASMR.
collected on swatches or on cloth, and then you wouldn't count them. So
Is there any, I'm sorry.
you could say envelope containing, and then it would be one envelope. So, but no, there has been no remedial, other than training, is that he clarify exactly how he's doing it.
Ms. Kessler, if a criminal collects 4 coins and puts them in a coin envelope for collection, is the individual criminal supposed to say coins under the word quantity number 4?
No, he could say,
That wouldn't be expected?
no,
Wait.
you could say envelope containing 4 coins. So, there are other ways of writing this.
So if in the property report it said either envelope containing 4 coins, or it said envelope coins and under quantity 4, both of those approaches would satisfy the requirements of the LAPD manual. Is that correct?
I don't think the manual's explicit, but that would satisfy my expectations, yeah.
In this instance, Ms. Kessler, Dennis Fung did not put down under quantity the number of swatches in the envelope. Is that correct?
Ruled. Do you know the answer to that question?
I believe there's additional swatches. No, he didn't put the number down, that's correct.
Nor did Dennis Fung write in the content area coin envelope containing 4 swatches, 5 swatches, or however many swatches there were, did he?
Again, I wouldn't,
Sustained.
I'm going to put these back. Now, as of June 12th, 1994, was it the policy and practice of the Los Angeles Police Department Crime Laboratory that no evidence shall be distributed to laboratory units for analysis unless either the booking criminalist accompanies the evidence at all times or the evidence has been officially booked at the evidence control unit?
Sustained.
Was it the policy and practice of the Los Angeles Police Department as of June 12, 1994, that no evidence shall be distributed to anyone other than the booking criminalist unless the booking, I'm sorry, withdrawn. Was it the policy and practice of the Los Angeles Police Department as of June 12, 1994, that for items of evidence that had not yet been booked, that the booking criminalist accompany the item to be analyzed at all times?
no.
Is that one of the procedures that is currently in the manual that has not been altered?
Sustained.
Do you believe it would be an appropriate measure to take to protect the integrity of items that have not yet been officially booked for the criminalist who collected the item or who will book that item to accompany it at all times?
Overruled.
It would be a nice thing to do, but in the absence of being able to do that or doing that, it should be documented, and that's all I would require. Who it was given to, what date, and when.
Was it the policy and practice of the Los Angeles Police Department Criminalist Unit as of June 12, 1994, that in instances where opinions are rendered as a result of any chemical or physical test and/or procedures performed in the field which cannot be reproduced in the laboratory, that a analyzed evidence report be prepared?
Overruled.
It is vague, but I think I can clarify it if you would like me to attempt that.
Please do.
If it's our policy is that we don't write analyzed evidence reports for screening tests, presumptive tests for the most part. You can, and that's one of the things that's even vague within our own policy, which needs to be clarified and will be in this manual. We will determine whether we're going to write them for every time or not at all.
Ms. Kessler, are you aware of the fact that Dennis Fung claims that in the first week of July of 1994, he went out to the Ford Bronco and he did a presumptive test on one of the smears that he observed on the saddle of the driver's door?
Sustained. Sustained. Rephrase the question, please. Argumentative the way it's going.
One moment. may we approach for a moment, Your Honor?
The way you phrased, I'm not saying it's an improper subject to inquire into. The way you
Okay.
phrased the question was argumentative.
Sorry. Are you aware that Dennis Fung testified that during the first week in July, he went out to the Ford Bronco and he did a presumptive test on one of the smears that he said he observed on the saddle of the driver's door?
I've been told that was his testimony. I have no personal knowledge of it.
And are you aware of the fact that that during that first week in July when he went out there, that he did not prepare an analyzed evidence report?
I have no personal knowledge of that.
Well, Ms. Kessler, when we met with you on July 13th of 1995, just last month, didn't you say that it would be the practice and procedure of your laboratory to require that a criminalist prepare a report, even for a presumptive test, if the person was not going to be able to collect the evidence and bring it back to the laboratory?
No, that's not what I said.
Wait, that is hearsay. It's not a 1235 issue. The objection sustained. Answer stricken.
Isn't it your policy and procedure as the director of the Los Angeles Police Department Crime Laboratory that whenever an analytic test is done in the field and the item of evidence cannot be collected and brought back to the laboratory, that an analyzed evidence report be prepared?
No, I don't think I said that even in that meeting. I think what I said was that it should be noted somewhere at least. The question of writing the report is what is up in the air at this point.
Well, when you say it should be noted, in other words, it should be noted that the person went out there, that the person conducted the test, and what the results were. Is that what you mean?
Yes.
Okay. And are you aware of the fact that Dennis Fung did not note anywhere that he conducted the test and what the results were?
Oral. Are you aware of that?
Oh, no, I'm not aware of whether it was recorded or not.
All right, Mr. Neufeld, about 15 minutes.
For a
Break.
break? Okay. One moment, Your Honor. As of June 12, 1994, was it the policy and procedure of the LA Police Department's Criminalist Laboratory to take whatever measures are necessary to protect the crime scene?
Whatever's in their power. The crime scene is, it would be nice that all criminalists can do what they can do at a crime scene, but the crime scene is already in control of the police officers, and it's not really our crime scene, it's the detective's crime scene.
Well, hasn't a memo been given out to all employees of the Los Angeles Police Department that it is the responsibility of the criminalist?
Sustained.
All right? I'd ask this, what is this next one called?
1318? 1318,
May I have a moment to read this document, Your Honor?
certainly.
Actually, Your Honor, it's already part of, maybe we should not mark it separately. The manual itself is already marked as 1071.
Then how about if we stop taking pages out of it?
Yes. How about it?
Why don't you just show that briefly to Mr. Darden so he knows what you're referring to, counsel?
All right. Your Honor, it's actually brought to my attention that there may be a reason to do this as a separate exhibit. And I will make a separate copy,
All right.
okay? But just to save time, may I show it to the witness?
Show it to Mr. Darden first.
Sure.
I think it's just the camera, where the camera is. Camera adds 10 pounds. He's one of the smaller boys I've ever had. Boys get big. I mean, he's not as small as a little girl, but he's got to go.
Which is a memo from the
No, you have to go.
head of the police department, Darrell Gates.
1974, not signed.
Have you seen that memo, which is directed to all personnel of the Los Angeles Police Department?
Well, it's a notice from 1974, if you give me a moment. It's before I even came to work for the department, and it's not signed by Gates, by the way. So I'm not sure it's official.
All right, do you have any questions regarding this item? I think we need to establish a foundation for it.
Right.
It appears to be a 21-year-old document.
I understand that.
I don't need to look at it. Not at this point.
Ms. Kessler, from time to time, is the Los Angeles Police Department's policies and procedures updated by memos that emanate from the Office of Operations or from the Office of Operations?
Well, I don't believe that's where it emanates from now, because Office of Operations, for example, has no functional responsibility over me. So I think it's changed.
All right. Well, was there a time when procedures that were to be implemented for all personnel would emanate from the Office of Operations of the Los Angeles Police Department?
Objection to the 1974 amendment.
It's irrelevant if there was a time.
Is it the policy of the police department that the Los Angeles Police Department manual contains procedures and policies that have been enacted and implemented many years ago? Isn't that correct?
Yes, some that are no longer in effect.
And in fact, they stay in effect until such time as another memo replaces them. Is that correct? Or determines that they are no longer in effect? Isn't that the policy and procedure of the Los Angeles Police Department?
Sustained. Ms. Kessler, is this item that you have here, 1318, to your knowledge, is that a current document?
It's unclear to me whether it was even, when it's Office of Operations notice.
No, Ms. Kessler, listen to my question.
Okay.
To your knowledge, is that a current, in effect, policy?
I'm not aware of it because it
All right,
appears to
that-
be
no, wait.
directed to
Just
somebody
yes
else.
or no? To your knowledge, is it yes or no?
I don't know.
Next question.
Did you say to this jury a while ago that you reviewed all the contents of this crime scene field guide manual that was prepared for your division of the police department?
Sustained.
Did you say that in 1992 you reviewed the contents of the draft version of the SID division's field unit crime scene manual?
No, I said I began to review it, and in beginning to review it, I saw many things I wasn't in agreement with and sent it back. So this is not one of the things I got to.
So you're saying when you reviewed the manual, you never noticed this document from Darrell Gates in it?
I didn't get that far in the manual. There were a lot of things up front that I thought were missing or unclear or not what I thought was our policy, so I sent it back for review.
Well, would you agree that it is the policy and procedure of the Los Angeles Police Department as of June 12, 1994, that to whatever extent possible, efforts should be taken not to trample or obliterate evidence?
Yes, I would agree.
And from what you have learned of this case, from the testimony of other witnesses, in your opinion, if Mr. Goldman's body had been dragged over a glove, hat, and an envelope, and through the soil, and those items were then moved, would that be in conflict with the policy and procedure not to trample or obliterate evidence?
Sustained.
Well, let me ask you a hypothetical.
Oh,
Assume for a moment that Mr. Goldman's body had been dragged through the soil and disturbed items of evidence or potential evidence that were lying on the ground, including such items as an envelope, a glove, and a hat. Would that constitute trampling or obliterating evidence?
In fact, not an evidence, improper hypothetical.
Assume that Mr. Goldman's body had been dragged over the ground, and in the course of it, an envelope and a glove.
Sure. Without report. right, thank you, counsel. Let's wind up in a couple of minutes or our break.
By the way, was it the policy and procedure of the Criminalist Laboratory on June 12, 1994, that it would be the appropriate thing for the criminalist to conduct a quick search for perishable evidence before then going back and doing a more thorough search of the scene? Would that be the standard procedure?
You would like to do that. Oftentimes, you can't get into a scene for some reason, but that would be the ideal condition.
And would you agree that it would be dangerous to remove a body over perishable items of evidence, such as a glove, hat, and envelope, before those items are removed from the scene?
Overruled. Overruled.
When you say over, removed over, if they don't touch the items and the body is on a plastic sheet provided by the coroner or something, so you could protect it and you were careful not to touch the items, you could hypothetically carry the body over them. If you mean that they're going to roll the evidence around or something, that would not be an ideal situation. You would prefer not to have that happen.
Okay. And was it also the policy and procedure in 1994 not to contaminate the scene?
Overruled.
Well, again, contaminate, that's a question. It's almost impossible not to walk in and out of a scene and bring possibly something into the scene or take something out of the scene, but you make all efforts not to contaminate the evidence. I'm not sure what you are.
As a director of the laboratory, would it be appropriate, would it be scientifically appropriate to take crime scene evidence from one crime scene and carry it into a second crime scene?
Not,
Overruled. It's not hypothetical. It's a policy or practices or procedures question.
as long as the item of evidence is already contained within something that was provided by the laboratory, let's say a container of some sort, and as long as it isn't allowed to be, if you don't take it out and shake it in the air or something, I don't see any problem with that.
Oh, I mean, as long as you don't shake it in the air, it's okay to bring an item from one crime scene to the other?
Yeah,
Is
there's
that your
no-
testimony?
Yes, there's no reason not to do that. I'm trying to think of something, if you're referring to the glove, let's say. If you don't take it out, you simply have it in a closed container where it isn't have any contact with anything else, and you look in the container and you don't take the glove out over any other evidence, there's no reason, nothing's going to happen to it. I mean, there's nothing flying around in the air that's going to fall in there.
Well, what about other hair and trace evidence that may be in the area where all these police officers are moving around when the bag is opened?
If that,
Isn't there a possibility that other hair or trace evidence can land on an object if it is brought into the crime scene from another crime scene and it is not in a closed package at all times?
Overruled.
it's a remote possibility. If that was true, you'd have to really be generating some turmoil in the area. Otherwise, you'd have hair and fibers all over everything all the time. We'd never get any crime scene evidence that was of any value.
Exactly, Ms. Kessler, and isn't that one reason why you don't want to bring items from one crime scene to another crime scene to risk that kind of thing happening?
Sustained.
Could we take a break right now? Thanks.
All right, ladies and gentlemen, we're going to take our mid-afternoon recess. Please remember all my admonitions to you. We'll take about
And they've all testified to much of what we've heard already. And at this point, we'd like to make an objection pursuant to 352 that a lot of what we're hearing this afternoon is cumulative. We've heard it before. It's not in dispute. We've reached a point of diminishing returns, and we'd object to having to hear this all over again, Judge. I mean, unless it's something new, why put the jury through this again? They're bored. They're bored. I'm bored. It's obvious that you're bored and restless by it.
Oh, no, I'm not bored. I've got 3 pages of notes today. I'm not bored at all.
Okay.
I'm tired, but I'm not bored.
And a second issue, if I may.
Yes.
As I understand it, the defense has one witness for tomorrow, Mr. Aguilar, the fingerprint expert. As the court pointed out this morning, this jury has been sequestered 6 or 7 months. They're here. They have indicated to us that there are other witnesses that they want to call. Let's call them. All right.
Gentlemen, let the record reflect that we've been rejoined by all the members of our jury panel. Ms. Kessler, would you resume the witness stand, please? All right, Michelle Kessler is on the witness stand undergoing direct examination by Mr. Neufeld. And Mr. Neufeld, you may complete your direct examination.
Thank you. Ms. Kessler, are you familiar with what has already been admitted into evidence as People's Exhibit 163H, the sub K, which would be the gray analyzed evidence envelopes, which are used for items that are to be refrigerated? Are you familiar with these?
I'm somewhat familiar, yes.
Well, I mean, when items of evidence are brought over to your laboratory for analysis, they may be serological items, they may be items for urine analysis, whatever. They would frequently be contained in those very envelopes, would they not?
Yes.
That's the standard Los Angeles Police Department issue, is it not?
I just want to make sure this is the most recent one. I believe it is, yes.
Okay. And in fact, these envelopes are used to, again, maintain the integrity of the security of the items that are contained within. Isn't that one of the purposes?
Yes.
And in fact, isn't there special analyzed evidence sealing tape, that is tamper-resistant, that is to be used on these envelopes to seal the contents of them?
Yes, assuming they're not within another container. In other words, if you book this alone, then you use the tape on it, yes.
Indicating one envelope by itself?
Yeah, in other words, if you're booking one vial of blood in this envelope by itself into evidence, this is my final packaging, then the seals go on this envelope.
It's your position, ma'am, that no seal is required on that envelope if the envelope is going to be put in a box with other items?
That's correct, because in that it's closed and then the box is sealed. So it's only the outside container, the most outer container, that is required to be sealed. Most outermost.
May I put this up on the other one? Can you focus in on the, can you focus in on the two boxes? Can you blow those up a bit? Okay. Do you see where it has instructions for the officer requesting the withdrawal of blood?
I can read the large print, I cannot read the little print.
Okay, perhaps I can read it to you.
Yeah, I would object to showing this to this witness. Those instructions are for an officer, and this witness is not an officer.
Oh, well, not at this point. What's the next question?
Do you see where it says on the instructions for this gray envelope, item number 4, when the affidavit is completed, sign below it as a witnessing officer and seal the vial in this envelope using completed sealed evidence labels. Do you see that?
I see that, yes.
Okay. And
Can you read that, Ms. Kessler, from that?
I can see that, I think that's what it says, yes.
right, and that use of sealed evidence labels, in particular using the tamper-resistant analyzed evidence labels, is to be done to maintain the integrity of the vial that is inside the envelope, is it not?
Yes, again, that's assuming you're booking that envelope by itself.
Is there any procedure in writing that you can quote to us which says that that specific instruction on that envelope does not apply to this envelope if the envelope is going into a box with other items?
I don't know a procedure, I just know that that's properties procedure, and that because you have to seal the external container with, in other words, I wouldn't even use this envelope inside another package. I would use a plain brown envelope, because you put a gray label on the outside of your box and seal the entire box, because all the contents has to be sealed and protected, not the individual items inside. This is for primarily deuces, arrestees who are arrested for drunk driving cases, where all you book is that envelope with one vial of blood, and that's the entire evidence in the case.
Was this same envelope used also to book blood in this case?
I believe it was,
And
but
it would, I'm sorry.
I'm not sure which blood and whose blood and how it was booked in final packaging.
Isn't it the standard procedure that for items that are to be refrigerated, which in this case would be a reference vial of fresh blood as opposed to a dried blood stain, that it would be placed in one of these gray envelopes?
If that was the only piece of refrigerated evidence, if it all fit in one envelope, yes, counsel. If not, you would use a box with a gray tag or a gray envelope taped to the outside.
I'd like you to assume for the purpose of this hypothetical that a reference vial of Mr. Simpson's blood was collected on June 13th, 1994, and was placed in a gray envelope, very much identical to the one that is up on the screen.
Okay.
In that situation, would it not be required that the tamper-resistant analyzed evidence seal be placed on the outside of that envelope for security purposes?
If that envelope, again, as I said before, if that envelope was booked by itself, by whoever booked it, then that booking individual would put the seal on the envelope.
To your knowledge of this case, and as the person who managed it ultimately, was any other reference sample of whole blood taken into custody on June 13th, 1994?
Sustained. It's in fact not an evidence of the way you stated the question as well.
Do you have any knowledge at all that, aside from Mr. Simpson's reference sample, of any other samples of fresh blood or whole blood, liquid blood, being taken into custody on June 13th, 1994?
Overruled. Overruled. To your knowledge, are you aware of any other blood sample?
No, not to my knowledge.
And if that blood sample was the only sample placed in the gray envelope, and there was only that one gray envelope on June 13th, wouldn't it be the appropriate procedure and practice of the Los Angeles Police Department to place the tamper-resistant analyzed evidence seal on that envelope?
No one,
Overruled.
it's okay, no one, no officer that I know of or have ever seen or anyone in my experience ever puts the seal on until they complete their prop report because they have to look at the vial. They then put their seal on before giving it over to the property custodians.
You say they have to look at the vial. You mean they have to open up to make sure there's a vial inside?
They have to physically look at the vial to see what the vial says so they can transmit that information on to their property report.
And you're saying that isn't it the practice, purpose, or another to analyze evidence or to examine evidence?
If it was sealed, yes.
Okay. So there is nothing to prevent a criminalist from opening a sealed envelope once it is sealed for the purposes of looking at what is on the vial and noting it on a property report, is there?
Sustained.
In fact, to your knowledge, at some point in time, were sealed tape, tamper-resistant sealed tape, placed on the envelope which had Mr. Simpson's blood in it.
Overruled. To your knowledge, was that done?
I believe so. I don't recall if it was booked separately or in another container. I don't recall.
Which photograph are you showing?
Exhibit 183 in evidence, prosecution exhibit.
Which photo? What is it?
It's a photo of the gray envelope which
Proceed.
contained the reference sample in this case.
Proceed. Mr. Harris, can we zoom in on any part of this?
Now,
All right.
you want to do it with this one instead? We have a photo, we can put it up as a photo. This is the same photo, it's just on the other. Now, Ms. Kessler, what I'm showing you now is a photograph of the actual gray envelope that was used to contain Mr. Simpson's reference sample when the blood was drawn from him on June 13th of 1994. Can you see it?
Yes,
All right.
barely.
And as you can see, at least when this photograph was taken, you can see the remnants of the sealing tape on the upper portion of the envelope. Is that correct?
I presume it's a sealing tape, yes.
Okay. So at some point in time, sealing tape was placed on the envelope. Would
That's
that be a fair
correct.
statement?
That's correct.
All right. Now, however, as you can see on the affidavit portion, on the instructions portion, for the officer requesting withdrawal, even on this envelope, the one actually used in this case, it states that when the affidavit is completed, sign below it as a witnessing officer and seal the vial in the envelope using completed sealed evidence labels. Is that the instruction on that envelope, which is up on the screen?
Yes.
Okay. And are you aware, number one, that there's been no testimony in this case by Detective Van Adder, who was present at that time when the blood was drawn?
Sustained. Sustained.
Right. Well, would it be an appropriate police procedure for no sealing tape to be placed on that envelope either by Detective Van Adder or Dennis Fung until several days after the evidence is collected?
Sustained.
Would it be an appropriate procedure of the Scientific Investigation Division of Los Angeles Police Department not to put sealing tape on this envelope for several days after it is collected?
It's vague. Rephrase the question.
Okay?
Do
Would it be,
do you know the time period?
yes.
Rephrase the question.
Would it be an appropriate procedure of the Scientific Investigation Division for neither the police officer who instructed the nurse to collect this blood sample or for the criminalist who initially received this blood sample to put any sealing tape on that envelope for the first 48 hours after it has been collected?
I don't know what the time frame has to do with it. It would not be unusual, and I believe it is the practice of the Los Angeles Police Department officers and personnel in the Criminalistics Department not to seal evidence with the evidence tape, and I believe it's in the property manual, but I'm not positive. I'd have to look, to seal the evidence until you book it, because, again, there's no reason to. It's in your custody.
What you're saying then is that the instruction that is included in paragraph 4 of the same envelope that was used in this case.
All right, counsel. We've asked this question now in 8 different forms.
By the way, you know Detective Van Adder, do you not?
Yes?
He's a friend of yours?
When you say friend, I know him on the department as, many people on the department are my...
Well, you've known him for many years.
Yeah.
And you're on a first-name basis.
Yeah.
Okay. And by the way, your husband also works for the Los Angeles Police Department, doesn't he?
Yes, he does.
And he works in robbery homicide, isn't that correct?
He works in the robbery, homicide division, bank robbery section.
And robbery homicide is the same division that Detective Van Adder and Detective Langer are in?
Yes.
And all their offices are on the 3rd floor over at Parker?
Yes.
As the person who was ultimately managing this case, as at that time the assistant director of the laboratory, were you aware that Dennis Fung and Andrew Mazzola went out to collect evidence from the Bronco on the 14th of June, 1994?
Oh, well,
I'm not clear. When was I aware of it? I was aware of it after they did it.
Yeah.
Oh, okay.
And would it be the standard policy and practice of the Los Angeles Police Department that the criminalists are to collect any and all potentially relevant evidence each time they conduct a search?
They're to make a judgment as to what they feel is relevant, yes, and then collect it.
Fine, but once they make the judgment that it's relevant, they're to collect everything that they conclude is potentially relevant, correct?
Well, everything that's relevant, but not necessarily all of it. If you have a huge pool of blood, you're not going to take all of it.
Right. But if you have a series of small stains, as opposed to a huge pool of blood, then it would be appropriate to take all of it, correct?
No, if you have, not necessarily, no, but if you have a spatter pattern that appears to all be one pattern, you have to make these judgment calls. You're not going to necessarily take all the blood from a pattern that you believe is all from one individual. You're going to take a representative sample. The same with a trail of blood. If it appears to all be from one individual and it goes for miles, you're not going to necessarily pick up every little stain along the
I'm
trail.
not talking about things for miles. I'm talking about stains in a Bronco. Okay, Ms. Kessler? And the question is this.
it is. The way the question was phrased, it wasn't confined to the Bronco. Restate the question.
I'm asking you about the Bronco, and my question is this. Was it the standard practice and procedure at the Los Angeles Police Department Crime Laboratory on June 12, 1994, that as to any particular stain that they collect,
I
I'm not
looked,
talking about
and
huge pools of blood, I'm talking about a
there's a different
confined stain,
disciplinary hearing
that it was
coming on
the
today, I
instruction
think.
and procedure at your laboratory that they were to collect as much of a stain as possible if it was going to be used for DNA analysis.
Again, it depends on the size of the stain. You try to collect an adequate amount, and we've described that over the years in different amounts. When DNA first started, we said we'd like a quarter-size sample. We're down now to a nickel-size sample. So, if that's what you're asking.
What's next in line?
1319.
This is it? I'll show you 1319.
All right, what court report, please?
I just can't fast forward this. It's so stupid. It either goes way too far. It's so frustrating. There needs to be a better way to fast forward a stupid YouTube video.
All right.
Okay,
But we do need a contextual foundation,
Okay.
just so they understand what this is.
I'll show you what has been marked
1319.
1319, three-page document entitled Collection and Preservation of Body Fluids, and ask you to take a look at it.
Is there a specific section you want me to read?
Yes, but first what I'd like you to know is this a document that was given as a handout to the criminalists, as opposed to something that would be part of the manual?
Yes.
Okay. Now I call your attention to
Page 2, item 14.
page 2, item 14. Thank you, Your Honor.
Is this a current or contemporary document in your lab?
I'm not sure if this has been modified. I do know that this is a handout, and then there is some narrative training that goes with this.
All right, would you look at item 14 on page
Okay.
2 and tell me if that is a current policy?
That's basically a current policy, again,
All right.
depending
No,
on
no,
size.
Just,
I'm
yes,
sorry,
sir.
Your Honor.
All right.
In the handout that was given to the criminalists who are going to be involved in the collection and preservation of body fluid evidence, doesn't it say in number 14, collect as much of the stain as possible, especially if RFLP DNA analysis may be necessary as a future analysis? Is that the instruction that was given to the criminalists in this handout?
That's what,
Perhaps just for the jury's sake, you should yellow highlight that particular portion on page 2 so the jury, when they see it, will know what it was we were looking at.
If I can remember those two
For
letters,
the jury's sake,
Zach, you
yellow
just
highlight
saved
that
me
particular
because,
portion on page 2
gosh,
so the
I
jury,
get
when
so
they see it, will know
frustrated.
what it was we were looking at. No, just put it,
That's not necessary. We'll do that in.
Yeah.
Okay. Thank you, Your Honor.
because when they get this a week or so from now to look at,
By the way, is it one of the responsibilities of the SID unit to maintain the integrity of those items of evidence for which there will be some kind of, some biological analysis? Is that one of the responsibilities of your unit?
I'm not clear. Could you be more specific?
Well, if there are items of evidence which are going to have to be analyzed, let's say for a serological analysis, a DNA analysis, would it be a responsibility of the criminalists at SID to maintain the integrity of those items?
We're responsible for handling them. There's many items of biological evidence we never handle.
Now, in this particular case, you went out to, you learned, I'm sorry, that Dennis Fung and Andrew Mazzola went out to the Bronco to collect bloodstains on the 14th of June. You learned that sometime after they came back, is that right?
I believe so, yes.
Would it be a couple of days later that you learned that?
I don't recall
All right.
when it was.
But it was sometime shortly thereafter?
Probably,
All
yes.
right. And you went out to that Bronco on August 26th, 1994, is that correct?
That's correct,
And you collected evidence on that day?
yes.
And when you went out there on the 26th and you looked inside the Bronco, didn't you exclaim at that time,
or
didn't you exclaim words to the effect that, oh my goodness, look at all the blood stain that is on this console, something like that?
I don't believe I exclaimed it. I didn't say that I said, oh, there's still blood here, yes. I was surprised.
And you learned, did you not, that between June 14th, 1994, and August 26th, that Bronco had been gone into with people who did not have authorization to do so.
will.
You learned that, didn't you?
Eventually, I'm not sure when.
And you learned, did you not, that in fact, another member of the Los Angeles Police Department, Detective Muldorfer, conducted an investigation into people who had unauthorized access to that vehicle. Did you learn that too?
Sustain. It's irrelevant.
I think so.
Jury
Well-
knows about that.
Okay. Well, as the director of this laboratory, did you conduct any investigation into whether the evidence in that Bronco was in any way compromised, the biological evidence was in any way compromised during that 2-month hiatus between June 14th and August 26th when you went into the Bronco?
Oh,
I'm not sure what you mean by conduct an investigation.
Well, would it be a matter of concern to you, as the person who's head of the laboratory, that would conduct any kind of serological analysis on biological samples, such as bloodstains, that the Bronco had not been kept in a secure state from June 14th, or from sometime in the middle of June of 1994 until sometime in August 1994? Would that be a concern to you?
oh,
It would be a concern if there was a possibility that, other than someone getting in and looking at it or something, if they would have been bleeding in the vehicle or something.
Okay. Did you undertake any investigation as the director of the SID Criminalist Laboratory to see whether or not?
Well, first of all, it wouldn't be my place to do the investigation. I did ask if the individual that apparently got in the car bled in the car for some reason, and I was told no.
How do you know that there was only one person who entered that Bronco during that 2-month period?
sustain.
Do you know how many people entered that Bronco during that 2-month period?
Oh, do you know?
No.
What efforts did you undertake as the director of the Criminalist Laboratory responsible for the analysis of biological evidence to see how many people were in that Bronco during that period and what, if anything, they did while they were there?
We've already answered. Sustain.
Now, I'd like to ask you a few questions about the socks in this case, Ms. Kessler. Within a week to 10 days after the deaths of Nicole Brown Simpson and Ronald Goldman, Dr. Michael Baden and Dr. Barbara Wolf visited your laboratory, did they not?
Yes.
And they came there to observe items that had been collected and were being stored at your laboratory in connection with this case, is that right?
They were being stored in the property section, yes.
But when they came on that occasion, do you remember what date it was, by the way?
I have my notes.
Why don't you take a look?
Thank you. It's June 24th.
Okay. When they came on June 24th of 1994, you refused to allow those experts to physically examine the items, did you not?
Physically examine them?
Yes.
Could you define physically examine?
Touch with gloves on or look at under a microscope.
No, they could have looked at them under a microscope if they'd asked for a microscope. They could not handle the physically touch the items. We would have provided a scope and moved the items around for them.
They were not allowed to handle any of the items even if they used appropriate protection.
Right, because we had not looked for trace evidence at that point. It was very, very early on in the case.
Well, didn't you also at that point have a prohibition as to defense experts being present when your criminalists initially examined the items of evidence in this case?
We have a policy in the laboratory that we don't allow defense experts into the laboratory. That's correct.
Now, on June 29th, approximately 2 weeks after this case began, you participated in a review of the evidence then collected to see which items would be subjected to different types of scientific tests, did you not?
The purpose of that review was not for that reason. We did an inventory, essentially, and at the time, we made some notes as to what we might do with things, but the main purpose of that was not to decide what to do with the items. However, that was a secondary reason.
One moment.
So it was a reason, yes.
I'm sorry, you said it was a reason?
Yeah, it was one of the reasons,
Okay.
but the primary reason was to do an inventory.
And I believe you said earlier that you started examining that evidence sometime around 2:30 in the afternoon, and that the examination continued until about 9 or 9:30 in the evening. Is that right?
Sustain. Examination. Examination versus inventory.
Oh, I'm sorry. Okay. And didn't you, in fact, that you began looking at those items at about 2:30 in the afternoon, and you continued, the three of you, to look at those items until 9 or 9:30 in the evening?
I believe that's I know we started about 2:30 in the afternoon. I can't recall what time.
And the
we
three
started.
people who were doing this were yourself, your now
Be right
assistant
back,
directors
guys.
at
Be right
Mr.
back.
Matheson
Yes, that's correct.
and Colin Yamauchi.
That's correct.
And one of the items of evidence that you examined, one of the items of evidence that you observed and reviewed on that particular afternoon and evening was item 13, a pair of socks recovered from Mr. Simpson's home.
That's correct.
And after you examined that item of evidence, as well as the other items of evidence, the three of you prepared a report. Is that correct?
That's correct, but we didn't, I wish you wouldn't use the term examine, because we really didn't examine them.
Well,
We did a
you-
cursory look to see
you
if they were...
analyzed them.
No, we decided they were socks, and that they were dark blue or black, and I can't even recall. We didn't really analyze them at all.
Didn't you entitle the report that you prepared that evening, Summary of Analyzed Evidence by Analysis Performed?
That's not what I would have entitled it. Is that on the data printout? Because I have the handwritten one that does no title on it at all.
Was the handwritten report eventually put into type form?
Yes.
History mark 1320. And what I will do, Your Honor, since the only copy I have has certain markings on it, I will not publish it to the jury, and I will provide a clean copy.
All right, tomorrow morning.
Right.
With a foundational objection.
All right. She has the handwritten, you've got a typewritten.
I'm
Just
going
foundation, ask her to compare to see if they're the same document.
to ask you to look at this exhibit. And first of all,
Now you know I don't have this one. I can't read it even with my glasses on.
Ms. Kessler, before you can finish looking at that, didn't you personally provide us with that typed report at a hearing in this case?
Yeah, I brought
over
it
the
to court.
summer?
Yes, I brought it to court.
That typed version?
Yes, that had been prepared by our office.
Okay, and you were the ones you presented that to us?
Yes.
Okay.
It's just that this one is sorted differently, and I'm not sure it's the one I brought. It appears to be,
It appears to be the same. Thank you.
yes.
And isn't that typed report that your laboratory prepared entitled O.J. Simpson, Summary of Analyzed Evidence by Analysis Performed? Isn't that what it's entitled?
That's what it's entitled, but that's not correct.
So it's your testimony that your own laboratory put the wrong title on the document that you brought to court and introduced at that hearing. Is that
Well,
correct?
It's not entirely wrong, but that was not the main purpose of that document. There's some analysis had been performed. None on the socks.
And you have an independent recollection of that. Is that correct, ma'am?
Yes, I do.
All right. And in this report, comments were written by the three of you about these different items that were looked at during that day of June 29th, 1994. Isn't that correct?
Yes, on some.
All right. Well, was a comment written next to item 13, the socks that were taken from Mr. Simpson's home? I'm not asking you what the comment was. I'm asking you, was there a comment written in?
Yes.
And is the comment that was written in on the type report, or you don't have the type report, let's just deal with the handwritten report then. Is the comment that was written by you three collectively on the handwritten report, dress socks,
Objection, hearsay, on the foundation.
Oh,
is the comment that you wrote on the handwritten report,
It's not an evidence, you wrote this.
sustained.
is the comment that was put on the handwritten report that evening on June 20,
Sustained is the authorship. Ask the foundation question.
I'm sorry, I couldn't hear you.
Sustained is the authorship.
Okay.
Ask the foundation question, please.
On that evening, when you were there observing these items of evidence, which of the three of you actually wrote down the notes on the handwritten report that you have in front of you?
Most of these are written by Mr. Matheson. Appears, most of it.
All right? And are the comments next to item 13, were those written by Mr. Matheson?
I'm not sure if that's all his writing or not.
So if it's not Mr. Matheson's handwriting, then it's either yours or Colin Yamauchi's. Is that correct?
Yes,
But it's one of the three of you who was there observing the items.
yes,
And the comments that were written contemporaneous to the observations of these items. Is that correct?
that's correct.
As to item 13,
Does this accurately reflect your observations?
Yes,
The notation is item 13.
yes.
okay. And is the comment that was written next to item 13, when the socks were looked at by the three of you, quote, dress socks, blood search, None obvious. Is that what was written?
That's what's written.
Okay.
Do you
And
want,
would you agree?
All right, have you finished your answer?
oh, that's what's written. That's
Okay.
not, though it depends how you read it, what it means, though, so.
Well, does, one moment. Isn't it a fact that each of the items that was looked at on that day was removed from the packaging it was in and laid out on a piece of laboratory paper?
I believe everything was taken out. I don't know whether they were taken completely out and laid out. You know, they were taken out, looked at, and put back. They were not thoroughly examined by turning them over and those sorts of things.
Are you aware that Colin Yamauchi testified that each and every item was taken out and laid on a piece of laboratory paper?
Sustained.
How many years' experience do you have as a criminalist?
Well, do you mean prior to being a lab director or all my years?
Yes.
Yes. Oh, I'm still a criminalist because as
How many years have you
lab
been a
director-
criminalist?
Since 1976.
How many years has Mr. Matheson been a criminalist, approximately?
I don't recall when he started, probably about 78,
So between you, you have perhaps 30 years of experience?
perhaps. Yes.
Mr. Yamauchi, how many years has he been a criminalist?
I can't recall the exact year he started. I believe about 3 or 4 years.
So between the three of you, you have almost 35 years' experience.
That's correct.
And based on your experience, would you not know that if there is a blood stain on black socks, one has to look somewhat carefully at those socks because of the color of them?
Yes, I would expect to have to look very, very carefully.
And you knew that based on your experience?
Yes.
And yet you say that when the socks were observed on that night, the comment you put on the report was blood search, none obvious. Is that correct? Is that correct?
That's what we wrote, but now
That's
can
what I'm
I
asking you. Is
explain
that
what
what
it
you-
means?
Wait.
Your Honor, I would
No.
ask that the rest of the answer be stricken as non-responsive. I simply
No,
asked
no,
whether the comment was made.
wait.
Okay.
All she said was, may I explain the answer? That's all she said. But you interrupted her and talked over it. You're driving the court reporter mad. That's the only thing I would like you to do. That's all she said. Ask another question.
Fine. No further questions to the witness, Your Honor.
Mr. Dard?
Thank you, Your Honor. Good afternoon.
Good afternoon.
When you examined the sock, that was what, on June, what was that date?
June 29th.
Okay. And you didn't examine the sock, you looked at it, is that correct?
Did a cursory look at each piece of evidence to determine what analysis, if any, we were going to perform, as well as inventory it.
Now, when a criminalist is doing a detailed search of an item for blood, you use high-intensity light to examine that item, don't you?
That's one of the things, yes.
Okay. Did you use high-intensity light when you looked at the sock that day?
No, the light's about like in here.
Okay. And you weren't doing a detailed search for blood at that time, were you?
No.
Another means by which you would search for blood on a pair of socks, dark-colored socks, would be to use a microscope. Is that right?
That's correct.
Did you use a microscope that afternoon?
No.
And that's because you weren't conducting a detailed search for blood on the sock, were you?
No, we were just trying to determine what we might, and that's what blood search means. There was going to be a blood search done. We were asking for that to be performed. There was no obvious blood under these kind of conditions, office condition.
And is that what the notation means? Blood search non-obvious?
That's correct.
That doesn't mean that there's no blood present on the sock, does it?
Objection, Your Honor. That calls for speculation.
Sustained.
Well, in writing that notation, you weren't trying to suggest that there was no blood on the sock, were you?
Objection is what we're trying to suggest. It speaks for
This is
itself.
cross-examination.
Over.
No, we weren't looking for blood at all.
Now, when Mr. Neufeld asked you some questions, there were occasions when you wanted to explain your answers. Is that correct?
That's correct.
That's because not all of the questions could be answered with a yes or no answer in your opinion. Is that right?
That's correct.
What did you mean when you used the term blood search?
Oh, blood search would be later on. In other words, one of the things that those socks would be looked for was blood. We felt that had some knowledge that Mr. Simpson had cut his hand and those socks were found in his bedroom, and so we were going to search for blood on those socks.
And so you were planning to conduct a detailed search at some future point?
Yes, at some future point.
You mentioned a little while ago that on August 26th, was it, that you went and saw the Bronco?
I believe that's the date. I'm starting to mix up my dates here. Yes, August 26th.
And that was at Keystone Tow?
That's correct.
And that was in a secured facility?
Yes,
And you went there with other criminalists, is that correct?
yes,
You went there with some defense experts, didn't you?
yes, that's correct.
And the search conducted that day was videotaped?
I believe there was a video camera that a member of the defense team brought, or someone. I think it was the defense.
Okay. And that would be Mr. Regal, who was present on behalf of the defense, is that right?
I think so, yes.
Okay. And there was an SID photographer there?
Two SID photographers.
Did the defense also send a photographer to the Bronco that afternoon?
Well, they had another expert there, and they took pictures, and I don't know who necessarily took the pictures.
Okay, so you gave the defense access to the Bronco while you conducted this additional search, is that right?
Yes,
They were present.
that's correct.
And when you looked inside the vehicle, you noticed blood, is that right?
That's correct.
You noticed blood on the console?
Or what appeared to be blood, yes.
Okay. Did you notice blood on the steering wheel?
Objection, Your Honor. Sidebar, please.
With the court order.
Mrs. Kessler, you've seen blood before, right?
Yes,
And when you looked in that Bronco, you saw a number of red stains inside, is that correct?
yes.
You see a red stain on the door, interior door?
Uh,
Vague. I assume the car has more than one door.
Yeah, I was going to say.
Got me, Your Honor. Did you see a red stain on the interior driver's side door of the vehicle?
I believe so, yeah. Yes, yes,
Did you see a red stain on the driver's seat?
yes.
Did you see a red stain on the armrest? Or console?
On the council, yes.
Okay, would that console be located to the right of the driver's seat and in between the driver's seat and the passenger seat?
That's correct.
In fact, you saw more than one red stain on that console, is that correct?
It appeared to be, yeah, I think it was more than one. It was difficult to tell if it was continuous. It was a faint smear over a large area, and then it was difficult to tell whether it continued around or if they were separated.
Okay, and was it your understanding that those areas had already been swatched by Dennis Fung?
Objection.
Sustain.
You can see that blood, is that right? I'm sorry, you can see those red stains, is that right?
That's correct.
And was it your understanding that the blood on the console had already been swatched?
Based on previous,
Objection against any objection.
Sustain.
And looking at the red stains that you saw on the console, could you tell just by looking at them whether or not they had been swatched?
up close when they were observed, they appeared to have been smeared.
Is that consistent with the stains having been swatched?
Yes,
You told us earlier that you inventoried some items, is that correct?
yes, on June 29th. Is that, I'm sorry.
By the way, did you ever inquire of anyone at Bertell's Tow as to whether or not anyone had bled inside that Bronco?
No, At Vertel's, no.
Okay. You inquired of someone else?
No, I believe I asked the detectives, or I was told that some,
Sustain. Sustain.
Your lab does not allow defense experts inside the lab?
no, not routinely. There's a policy.
Is that a written policy?
No, it's not in writing.
But that is the lab policy, isn't it?
I take that back. It is in writing for the firearms unit, but not for the rest of the laboratory.
But
Yes.
Okay. But you changed that policy for the defense in this case, didn't you?
Objection, Your Honor, that's assuming facts, not in evidence.
Foundation.
Well, given your policy precluding defense experts from entering the lab, in this particular case, did you allow defense experts into your lab?
Yes, we did at the request of your office and our higher authorities in the department.
And in fact, you've made your employees available to the defense to be interviewed, is that right?
That's correct.
You've been over backwards for the defense, haven't you?
Objection.
Oh, whoa.
I believe we've done as much, and in fact more in some areas, than we do in normal cases. When I say normal cases, I mean on a normal basis.
In fact, haven't you actually opened the lab on a Saturday when it would otherwise be closed so that the defense could come in and examine the items of evidence in this case?
Yes, we did.
You also have a policy that precludes defense experts from being present when testing is ongoing, is that right?
Yes.
But have you allowed defense experts to be present while testing was ongoing?
Yes, in this case, again, we did in some instances.
And is there a reason that you don't allow defense experts to be present during testing?
Well, there's several reasons, but the two primary issues involved here is, one, we have to maintain the integrity and the confidentiality of all other cases, we have to put everything else away and no other work gets done at the time that that's going on. And the second reason is safety. I cannot guarantee the safety of any other expert in the laboratory, and we are liable.
And so if I understand you correctly, then when defense experts in this case are present inside your lab, no other testing goes on inside the lab?
That's correct.
So other cases that are being tested and analyzed by SID, those procedures have to stop, don't they?
That's correct.
How many cases do you process within the SID lab during any given year?
In a year, probably at least 50,000 plus cases a year.
Okay, can I have one moment? Just about done. You indicated earlier that you were concerned that Andrea Mazzola had been listed as OIC on one of the reports in this case.
That's correct.
Okay, and why were you concerned?
I was concerned because I didn't believe that she, in fact, was the OIC at the crime scene. My understanding was that Dennis Fung was, or the policy would be that Dennis Fung would be the OIC at the crime scene. And I was concerned that she was listed that way because I couldn't understand why that had been done. And that was later explained to me.
Now, Dennis Fung is a criminalist 3, is that right?
That's correct.
Andrea Mazzola was a criminalist 1.
That's correct.
And what is the policy? That is, when a grade 3 criminalist and a grade 3 1 criminalist goes to a crime scene, who's in charge?
The 3 is always in charge. He's the supervisor, or whether it's a supervising criminalist or a 3 or even a 2, they're always in charge.
And did I understand you to testify that Dennis Fung was not required to write a report when he conducted a presumptive test at the Bronco on July 6th?
Not a formal report, not an analyzed evidence report.
Now, you have a master's degree in criminalistics, is that correct?
That's correct.
And you had to write a thesis to obtain that master's degree?
Yes, I did.
And we've heard a lot about ASCLD. What relationship, if any, do you have personally with ASCLD?
I've been a member of the American Society of Crime Laboratory Directors since 1983, and I've been a member of the board of directors for the last 3 years, and I'm the chairman of the ethics committee.
You're chairman of the ethics committee for
That's
ASCLD?
correct.
Thank you.
Ms. Caslow, you said that earlier that that when you did the initial examination of items for hair and trace and the serological testing back in June in early July in 1994, that at that point in time, defense experts were not allowed to be present. Is that correct?
Overruled.
I'm not sure that it was done in early June or July, and you'd have to be more specific what you're referring to and where we did it.
Well, for instance, Dr. Lee was not allowed to be present. Dr. Henry Lee was not allowed to be present during the initial examination of items of evidence by people in your laboratory during the month of June. Isn't that correct?
If it was done in June, that's correct.
Okay. And in fact, isn't it true that the reason there were certain representatives of the defense team present on August 26th is because the court ordered the SID to give us access to be present at those testings?
I'm not aware of that. I didn't set up the search of the, are you talking about the Bronco? August 26th?
August 26th. the Bronco.
I'm not aware of how that took place.
Are you aware of the extent to which it required court orders from this court to have?
Sustained.
You said that when you looked at stains in the Bronco, they were smeared, and that was consistent with having been swatched. Is that correct?
Some of them were smeared, and within that smear, there was some obvious additional smearing or rubbing, and it could be, yes, it could be consistent with swatching.
Okay, could be consistent with swatching. It could also be consistent with someone rubbing their hand on a stain, could it not?
It could be consistent with something else. I wouldn't say rubbing your hand on it, no.
It could be consistent with someone rubbing something else on those areas other than a swatch.
Yes, that's what I just said.
And when you looked at those smears on the console, for instance, on August 26th, you don't know how they got there, do you?
I know that they're consistent with the previous photographs from the original search of the Bronco. They appear to be present in the same.
I asked you if you know how they got there.
Oh, no.
And when you looked at those smears on August 26th, you can't say when they got there, can you?
No.
And finally, calling your attention to June 29th, when you, Colin Yamauchi, and Greg Matheson looked at the items of evidence in this case, you said on cross-examination, quote, "We weren't looking for blood," unquote, in reference to the socks. Is that your testimony?
That's correct.
I don't know, I know we marked the typed version. I don't know if we marked the handwritten version.
I don't know if we have either. Do you want to mark that as 1321?
I would.
All right.
In fact, I'm only going to mark
Page
one page, which is going to be the page that refers to item 13.
Fine.
All right?
Do you know the item number? All right, let's mark it 1321. All right, want to put it on the Elmo?
Is item 13, would that be the, that's the third?
And I'm sorry, Counsel, I forgot your name. Mr. Spalding. Good morning, Mr. Spalding. Welcome. All right, people represented by Ms. Clark and Mr. Darden. Jury is not present. Counsel, I don't see Mr. Scheck, and I thought he was the point lawyer for the defense on the nighttime view.
He was, Your Honor, but I will appear in his stead. Mr. Harris is presently attempting to print out the written objections that we have, but I can orally explain to the court what our concerns are.
All right, and Ms. Clark, who's going to handle this for your side?
Mr. Hodgman, if we intend to handle it now, may I make a phone call, Your Honor?
All right, I see Mr. Yokelson's here.
Yes, Your Honor. Mr. Hodgman will be here momentarily. We're
All right.
talking about the view.
Yes.
He'll be here momentarily.
All right, because this is something I'd like to resolve as soon as possible, because if any modifications need to be made, any alterations, it'd be nice to do it, have more time to do it. And if we decide to cancel it, then we could all plan to do something Sunday night.
We're meeting right now, actually talking about some of that, so Mr. Hodgman will be right now.
Okay.
Your Honor, I have not received any offer of stipulation from the defense concerning foundation for the print expert.
So I assume we'll just do it by the book then?
I guess.
Okay.
Your Honor, that is an oversight because there were some other matters last night that necessitated my absence from the office. Basically, there are 4 print examiners that lifted 17 latent prints from the Bundy crime scene. We simply want to stipulate as a foundational matter that those prints were in fact lifted, and Mr. Gilbert Aguilar, who is now present, will testify about the nature of those lifts and what results, if any, were obtained.
Ms. Clark?
Put it right. That's all I want. I see it, I can see it. I'm sure I'll be glad to sit there, but I need to see it. I was informed when I came in that Mr. Tompkins approached the court to make a request concerning the removal of the tapes they had given to Judge Reed, and he ordered that into his court.
No, I indicated that they wanted to do some enhancement on the tapes, and I indicated that since Judge Reed has custody of the originals, and that matter has been transferred to Judge Reed has jurisdiction over those tapes. I can't issue any orders regarding removal.
Is
So,
there any time set for that? Because we'd like to hear it.
not that I'm aware of, but Mr. Bailey, when do you anticipate going up to Department 123?
On my way out the door, Mr. Yokelson, I've been waiting for.
All right, so we'll just sit here and wait for Mr. Hodgman and to arrive and for Mr. Harris to print out our objections. All right, is there anything else we can do while we're waiting? What's our prognosis of proceeding with witnesses tomorrow?
We have one witness today, who should be the
How about tomorrow?
We're going to have to discuss that.
All right, because I hate to have a completely down day. I mean, not that I couldn't use the day to do other things, since you want me to listen to 8 or 10 hours of audio tape and read hundreds of pages of transcript. It would be nice to not have to do that at home. But by the same token, you know, we have the jury in there, as I mentioned to you both yesterday. They're a little antsy.
We understand we are anxious to finish this case in the courts, and
Right.
the jury is.
Am I correct in my assumption that we're going to attempt to complete the defense case by the end of next week?
We had hoped to have an outside limit August the 28th.
All right. And as I recollect, Mr. Darden asked for a date to a target date to begin subpoenaing and rebuttal witnesses, and we'll start that about the 28th, give or take a day or two. All right. All right, then if there's no objection, just to, so that the jury understands our status, I'm going to tell them that despite the fact that we have downtime today and tomorrow, that we anticipate concluding the defense case sometime around the 28th, and the presentation of any rebuttal the week of the 28th.
Your Honor, the only caveat is that we cannot anticipate how long the cross-examination
Well, I understand that.
will be on some of our witnesses.
Believe me, they know that better than anybody else.
So that's, with that caveat, that's the matter.
All right. All right, here's Mr. Hodgman, and Mr. Douglas is present. All right, good morning, gentlemen. I thought we'd see if we can resolve any of the crime scene nighttime view issues this morning.
Very well, Your Honor. I thought I was being called down on another issue. I left my notes upstairs, but I think I recall all the pertinent information, so we can proceed.
All right, thank you.
Your Honor, Mr. Harris is currently printing out that which I'm about to read to the court, if the court pleases.
All right. Unfortunately, we're using a 2P here, so it's a little slow.
This is a letter dated today to Judge Ito. The defense renews its objections to a night jury view at the scene of 875 South Bundy. As a result of visiting the scene last Sunday evening, the court's investigation established a number of differences between the scene today and the way it was at the time of the incident that would significantly affect lighting conditions. There is some dispute about the street light overlooking the scene. The Taylors, next-door neighbors who offered evidence at our tour of the scene, said that the street light at the time of the incident was different, less bright blue halogen light, than the light currently at the scene. Apparently, however, the court has information from official city sources that the Taylors are mistaken. A Malibu, or small landscape light, midway up the front walkway, in foliage on the western side, was illuminated the night of the incident, but was stolen or is currently inoperable. Perhaps most importantly, a landscape light directly to the southwest of the front gate that was shining in the direction where Nicole Brown Simpson's body was found is inoperable. The light was found during our tour lying on the ground. Counsel has not been able to reconstruct from photographs precisely how this light was situated the night of the incident. Given the close proximity of this light to Nicole Brown Simpson, its correct placement is critical to recreating substantially similar lighting conditions. And in that regard, Your Honor, as the court will recall, Detective Lang opined that the light was designed to shine directly on the address 875, but however, it had been oriented in a manner to the right, or more towards Ms. Brown Simpson's body. Its absence, therefore, causes us greatest concern.
All right, I want to tell you that one particular factor is my greatest concern.
From photographs of the scene the night of the incident, it is clear that foliage from trees has grown up and obstructs light from a large porch-type light on the front of the condo near the half-moon window close to the roof.
Do you mean the two carriage lights that are out there?
Correct, Your Honor.
All right.
Since many witnesses testified how light cascaded down, obstruction of this major light source to some unknown degree creates a significant problem in recreating substantially similar lighting conditions. A tall plant at the top of the first stairwell on the southwest side is described by the Taylors, Ron Hardy, and Detective Lang as being taller than it was at the time of the incident. How much taller and how much of an obstruction this would cause to light cascading down from the half-moon window or from light on the first floor living room is unknown. Foliage is overgrown, according to all witnesses, namely the Taylors, Mr. Hardy, Detective Lang, and Van Adder, all of whom were present on Sunday, who were making statements during our trip, and obstructs light from the front door and front gate area. The night of the incident, there were many candles illuminating the living room that overlooked the front gate area. These substantial problems exacerbate two additional and intractable impediments to creating substantially similar light conditions. One, the night of the incident, there was moonlight, whereas the night of the proposed jury view, there will be no moonlight. Two, the night of the incident, there was some fog, whereas the night of the proposed jury view, there may be no fog. The serious difficulties in recreating substantially similar light conditions at Bundy, the necessity of taking testimony about the differences in lighting conditions, and the confusion that will inevitably arise in trying to assess the effects of a series of unknowable obstructions outweighs the need for a nighttime jury view. The jury has already seen the Bundy scene during the day, and nighttime photographs of the scene exist as it was just after the incident. Indeed, these photographs would have to be used during the proposed jury view in an effort to compensate for alterations of the scene. It would be less confusing, far less expensive, and less time-consuming to rely upon the night photographs, the previous daytime jury view, and the testimony of witnesses. The defense is also concerned about the issue of sound. The court's stated purpose for this night jury view is to recreate just lighting conditions, yet sound is equally important, if not a more important factor. The testimony of all timeline witnesses seems to be that once dogs began to bark, they continued to bark. The key issue is when did they start? Thus, the testimony of Mandel and Aronson and the question of what they could have seen walking past 875 South Bundy is less important than what they could have heard. Similarly, Heidstra's testimony is more ear witness as eyewitness testimony. Inevitably, the jury will be influenced in its assessment of what could be heard at night by their night jury view, even though that is not the court's purpose and sound conditions will not be replicated. In fact, the whirl of helicopters and commotion associated with the jury view will mislead the jury in terms of what could be heard. Lighting conditions is an issue the prosecution wants to pursue at a night jury view. Sound is the issue the defense wants to pursue, or wants to explore, Unless both can be substantially replicated, and unless efforts are made to recreate both, the night jury view at Bundy is unfairly prejudicial. Thus, if there must be a night jury view, the defense requests that efforts be made to recreate sound conditions. We also reiterate our request that the jury be taken to the location where Heidstra heard voices and the sound of a slamming gate, so they can fully appreciate how close those locations really are. One cannot adequately appreciate the proximity from aerial photographs.
Mr. Douglas, let me stop you right there.
Sure.
What are you proposing specifically with regards to the gate slamming? There are a number of metal gates at that particular location and immediately adjacent locations. And my recollection is in our informal discussions while we were out at the Bundy location last Sunday evening that it was the defense hypothesis that the gate that was slammed was the metal gate that's on the 875 South walkway that goes from Bundy to the alley to the west. Is that correct?
Correct, Your Honor. Not the front gate, not
Correct.
the front walkway gate. Correct.
But there's the small 3.5-foot high gate. Is the one
Correct.
we're talking about?
Yes, Your Honor.
Okay.
We have, on earlier occasions, retraced that scene with Mr. Heidstra, slamming various gates to determine which gate replicated the sounds he heard that evening. If necessary, we would propose recalling Mr. Heidstra or bringing him to the scene with testimony being taken in front of the jury and with a court reporter, such that we can then perform an experiment of slamming each of the gates, and he will then be able to identify which sound best replicates that which he heard on June the 12th.
My recollection of the crime scene photos is that the rear 6-foot gate on the Bundy alleyway, on the west alleyway, was open. And that the gate at where Miss Brown Simpson was found was also open. So the only other gate that would have been slammed closed would be the mid gate, but that gate was open as well, is my recollection.
I do think, however, Your Honor, a couple things that comes to mind. First, the slamming action is the clanging of metal against metal, and not necessarily the clanging of the door locking into its metal jamb. Therefore, in optimum fairness, it would probably be best for us to recreate each of the gates and to have Mr. Heidstra identify that sound which best replicates what he heard.
Did you,
Those gates, you can slam a gate, Your Honor.
I know you can slam a gate, and you can slam it hard enough that it won't have time to latch and it'll bounce
Correct,
back out.
that's exactly my point.
I've slammed gates before myself.
Very well. If I may continue.
No, I'm just asking you, I wanted to ask you, in the course of your experimentation out at the Bundy scene, did you do that and get that result?
I was not personally there. I am informed that an effort was made that each of the 3 gates were slammed, that it wasn't the back gate, that it wasn't the front gate, but that in fact it was the middle gate.
Right, but did you get that popping out result? Do you know that?
I personally was not there to be able to tell you.
Because we need to account for the state of the gate
I understand the
in a
question,
logical manner.
but Your Honor, I was not there to do that experiment.
All right.
Reading on, therefore we ask that a gate slamming demonstration be performed. As the court learned during our nighttime trip to the scene, Detectives Van Adder and Lang conceded they had performed that demonstration and the gate could be clearly heard. They just hypothesized one could not be sure which gate on the Bundy block was being slammed. There's a footnote with respect to the fog that I wasn't able to page down and I now have in front of me. And this was our concern about the impact that the fog would have on the actual ability to see at Bundy. Interestingly, the defense is informed by weather experts that the existence of fog creates more, not less, illumination from moonlight. And therefore, that is another factor that causes us grave concern that we cannot adequately duplicate and adequately replicate not just the view from the eye, but also to adequately perform or replicate the sounds that Mr. Heidstra heard. If we are to fairly perform this view, I think it prudent and incumbent upon this court to take issues that both sides wish to have replicated that are very germane and central to our search for truth into account. Since we are there, since we have the jury there, we would prefer, if there was a view to be performed, that it be performed in a fashion such that the sound and the eye can be adequately replicated for the jury to all see and also to hear. Given these problems, Your Honor, and given the costs that are clearly going to be incurred with closing off the freeways as we did before, clearing off the...
Let's not discuss those details.
Very well. Given those costs, Your Honor, we think the far better course is to allow the jury to rely on the photographs and to proceed with the trial without a jury view. the court is well aware that there are hundreds, if not thousands, of occasions when the search for truth is adequately performed without traipsing the jury to a location every time that a nighttime incident is germane or relevant. We don't think, in this occasion, given these grave concerns, that the interests of justice are best served by having this jury view.
Do you have any comments regarding the Rockingham residence?
The court expressed some concern at additional lighting that had been placed in the tree above Mr. Simpson's lights, his garage, and a plywood board that is now placed over the fence, which is used to obscure the views of tourists and bystanders. I spoke yesterday with people at Mr. Simpson's house, and I'm informed that, if necessary, it is possible to turn off the one light that was at it and to remove the board for the hour or so that the jury would be there, so as to fairly replicate the scene that Mr. Park may have seen on that evening. I share the court's opinion that opening the gates is not substantially similar, because certainly it's possible for there to be some obscuring of the view by the very nature of the gate being there. But that can be performed, Your Honor. We don't think that any view should take place, and we don't think that the interests of justice demand such. Thank you.
Thank you.
Ed, good morning, Your Honor.
Good morning, Mr. Hutchins.
And, you know, as the court is well aware, the issue here is not exact replication. It is not exact duplication. It's whether the creation of substantially similar circumstances can be had. It is the people's position that we can. It has been our position from the get-go that both a daytime as well as nighttime view would be instructive and, pardon the pun, but illuminating for the jury. Having, as trial counsel, having been there in the daytime as well as with the court last weekend, at nighttime, in my impression and in my assessment, it would be of value to the jury to have it both ways, to see it at daytime and nighttime. The question is, can the conditions at nighttime be rendered substantially similar to the way they were on the night of June the 12th, 1994? It is the people's position that, indeed, they can. This morning, I spoke with Mr. Robert Hernandez of the Department of Water and Power. He is upstairs and would gladly meet with counsel to provide to them the same information that he provided to me this morning. This is with regard to the street lights. The street lights in question, of which there are two, one in front of the Bundy residence and the second at what I believe is the southeast corner of the intersection of Bundy and Dorothy, I'm informed are the same as they were on June the 12th, 1994, that both of the lamps inside of those street lights were replaced in January of 1994. So they are indeed the same. And I was present when Mr. Taylor, one of the neighbors, said that he recalled some sort of difference in illumination, but it had to have been at a different point in time, because there is no documentation, there is no data that would indicate there has been a substantial change between what would be the viewing date and June of 1994. The street lights are the same. And again, Mr. Hernandez is present. I've asked him to stay to speak with defense counsel, and he is glad to share whatever information he has in that regard,
Right.
so that defense counsel is satisfied.
Did he bring his business records with regard to that?
He did.
And did he tell you what type of light is in there now?
Yes, a sodium high-pressure light, if I'm recalling correctly. Again, I came down prepared to address another issue, but from my recollection, that is the type of light. There was some mention last weekend of someone recalling a bluish type light emanating from the light, and there appears to be more of a, say, orangish type light that emanates now. I'm informed that when the present type of lamp first ignites, it does cast off a bluish type light for a period of about 5 minutes before it settles. The sodium high intensity aspect of these lamps is fully engaged, giving us the type of light that we witnessed last weekend. So the bottom line is the street lights are the same. There is no data or information other than, say, the recollection of the neighbors that the lights are different. However, the lamps were changed in January of 1994, and we have that data available to the defense.
All right, I think I think that is a critical issue. The two critical issues that I see on this that Mr. Douglas raises are the street lamps. So you may have to call Mr. Hernandez, allow counsel to review the records, cross-examine Mr. Hernandez as to these records, so that we have an adequate record.
Very well.
Secondly, the crime scene photos do have that orangish glow to them, and there's one in particular taken from across the street where the body of Nicole Brown Simpson is visible up the walkway, but also contained in the photograph is part of the overhead street light, and it clearly has an orange hue to it emanating from it. It doesn't have the blue-white halogen tint or glow to it. So the crime scene photos tend to be in accord with Mr. Hernandez and his records, it would appear. Why don't you address the landscape light, the foliage issues, the candles issues, and the moonlight issues and fog issues?
Very well, Your Honor. With regard to the Malibu or landscape type lights, an electrician has been summoned to replace the lamp in the light which would shine up to where the residence address numbers formerly were. And the same type of lamp would be installed, and an electrician is working on that to as closely duplicate the situation as it was on June the 12th, 1994. There was a second Malibu-type light, which I believe was up their stairwell a little bit. It was noted last weekend that that was out. The electrician is going to replace that as well. So as far as the Malibu landscape-type lights, that is being worked on and would have to be the subject of a dry run type review, if you will, to ensure that council is satisfied that that type of lighting is indeed substantially similar.
Yeah, I have the sinking suspicion we're going to spend our Saturday night doing this.
We'll inform our respective spouses to not plan anything for Saturday night.
All right.
With regard to the foliage,
Or we could all go out to dinner and then drive by.
this is the dry run. With regard to,
I'm being lobbied for Friday night instead of Saturday night. All right.
we'll see what we can do.
All right, Mr. President.
With regard to the foliage, Your Honor, with the assistance of Mr. Taylor and Mr. Hardy, the foliage that cannot be physically removed, such as the potted trees which have been put in place in order to screen the front of the residence at the Bundy location, that foliage is going to be trimmed back in accord with various photos and the recollection of two individuals who were very, very familiar with what the foliage was like at the time. The potted trees will be moved. The issue of attempting to duplicate the interior lighting, which radiated outwards from the residence over various aspects of the scene, can be duplicated simply by matching what we know from photographs and the recollection of investigators to the events of that night.
What about the candles?
I'm sorry?
Let's assume that the court will be able to make a factual determination on the foliage by comparing photographs of the crime scene taken in June of '94 with how it appears today. Do we know how many? My recollection is that we don't know how many candles were burning in the living room.
I think we have an estimate as to candles. I think that part can be created in some fashion. As the court has observed, however, the interior furniture at the Bundy residence has been removed. We will have to rely on photos and attempt to duplicate that as well.
All right.
In addition, Your Honor, I am reminded that we have a videotape of the interior of Bundy in that living room area, which would be able to depict placement of candles, and we'll take a look at that to ensure that the proper information.
All right.
can
My
be brought
recollection
forward.
is that there was also a two downstairs lights on within the interior as well.
Yes.
That will have to be illuminated.
Yes, the investigators recall that as well as I believe a light right over the entryway into the house.
All right.
So those matters can be addressed and be taken care of.
What about the moonlight and the fog?
Well, we don't have control over nature, and that, again, the test is substantial similarity and not exact duplication or replication. I would offer to the court that a stipulation of some sort be offered to the jurors so that they understand that there may be some difference there. Now, one thing that we will have to look into a little bit further, I mean, whether the moon was present or not, there's also the issue of the location of the moon at the time period in question. Last weekend, I noted, if I recall correctly, we appeared to have either a full or substantially full moon. And yet at the time we were out there, that moon was rather low in the sky and not in a position to be casting light from an overhead position.
Has your staff done any research on the percent of the moon that was illuminated and the moonrise, moonset times?
Yes. Your Honor, we have a judicial notice motion with regard to the phase of the moon and the information that the court just mentioned, which either has been lodged with the court or will be lodged with the court. But yes, our staff has determined that information. I don't have it at my fingertips at the moment.
All right.
With regard to Rockingham, Your Honor, again, relying on memory. As the court is aware, there were some differences in lighting at the front of the Rockingham residence. There were 2 spotlights in the tree nearest the house. We know that the brighter of the 2 lights up in the tree, this would be the light closest to the house, was not even there on June the 12th, 1994. The other light, we are informed, was not on. And that is a matter we will have to discuss with counsel, because I note protest from the defense side of the table, so that's something we're going to have to discuss, because our information is that light was on a timer. So perhaps they can be forthcoming with some information to us so that we can clear up that situation.
My recollection of our discussions at the scene, though, was that Detective Lang, if my recollection is correct, indicated that the light over the garage was illuminated. And the only light that's over the garage is that light that's in the tree. Because if you recollect, we inspected the exterior of the garage to see if there was any other light that might fit that description, and that was the only one that could possibly. And the residents there advised us also that the second light had been added for security purposes since these events. So there was one light in the tree overhead that, according to Lang, I think, was illuminated.
Okay, I'm not, Detective Lang recalls differently, at least based upon my informal interview with him this morning. We have testimony from the witnesses at trial that, if I'm recalling correctly, we have Alan Park describing a light on over the garage. And we will have that testimony assembled so that we can answer that more definitively.
My recollection is that's in the chart that my staff prepared for you.
Correct. Correct. Your Honor, in addition, as far as the lighting goes, there were carriage lamps flanking each side of the driveway in Ashford and Rockingham. That, again, we will have to more closely identify whether that illumination is recalled from the various recipient witnesses by examining the transcript. Those lights may have been on a timer or not. Mr. Douglas will illuminate us as to that.
Yeah, the indication was that our discussions at the scene were that they were on a timer.
Okay.
But they were on.
And
If
we
worse
want to
comes to
verify
worse,
that
what we can do there, let the jury see it first in a condition where those lights are off. Let them see it again when those lights are on.
With regard to lighting at that location, I've verified from Mr. Hernandez that the street light at what I believe is the northwest corner of Ashford and Rockingham is indeed the same lamp, and that was replaced in December of 1992. So the lamp is the same. It has not been changed since June the 12th, 1994 till today's date. There is the issue of the lighting emanating from the Salinger's house. The court might recall some of the discussions last Sunday night wherein there was information that some of the foliage at the Rockingham residence had been trimmed back, perhaps now what amounts to about a week and a half ago. The tree closest to the house, as well as 2 trees in the interior area within the semicircle of the driveway, have been severely cut back. The foliage separating the Salinger's residence to the south from the Rockingham residence has been thinned out considerably and trimmed back as well, thereby allowing present illumination from the Salinger's residence to go filter through over to Rockingham. Based on interviews that have been conducted with the Salingers, some of the present lighting, which can be described as security type lighting, was not there on June the 12th, 1994. To address that issue, it's a simple matter of turning off the lights. So we will be able to duplicate things from that aspect.
Do you have a statement from the Salingers indicating which of that security lighting was added since June the 12th?
And I should have that today, yes. I have the information, I don't have the statement in
All
here.
right, would you fax that to Mr. Douglas then as soon as you receive it, if it were not still in session?
I'd be delighted.
All right.
The foliage, however, we cannot change. My proposal to the court is that, much as the court suggested with regard to Bundy, just so that we don't create a false impression with the jury, is that we have photos enlarged of the Rockingham location with the manner in which the foliage was on June the 13th, 1994.
Have you undertaken to select representative photographs and have those enlarged? Because that's a time-consuming process. You may need to get that process started.
And, yeah, the process is underway.
All right.
Your Honor, what remains are the so-called the sound demonstration issue. If I can begin to address that now, I can simply state that the people are opposed to the suggested sound demonstration because what we're doing is conducting an experiment or demonstration in the presence of the jury. As the court will recall from the testimony, as well as the exhibits identified when Mr. Darden was cross-examining various witnesses, is that there are a number of gates in the vicinity of the Bundy residence. Photos of those gates were introduced in evidence through the testimony of one witness. We've had investigators in the area who've identified a number of gates as well. I do not believe we can create a substantially similar situation. I think we create a very speculative type situation with regard to that. So we have a whole different set of parameters with regard to the so-called sound demonstration, and for the record, the people object to that. I would remind the court as well in conclusion, unless there are any other questions that the court has of me, this is something that was contemplated from the very beginning. This was something that the people proposed in order to aid the jury in the resolution of the issues of this case, that there be a daytime as well as nighttime view. The court has had the benefit, like I have, of both. I think the daytime view was very instructive for the jury. Two-dimensional photographs, however enlarged, however enhanced, can only do so much. I would have to think that the court would agree with me that the daytime view was very helpful to this jury in understanding the dimensions involved with both locations, but most particularly Bundy. With regard to the nighttime view, it is indeed different at night, and I was impressed last weekend with the value of understanding the added dimension that darkness and the appropriate lighting of each scene at the time played, at least in my mind, in terms of understanding the events of this case. So I will close with that.
Right. Your Honor, with all due respect to Mr. Hodgman, whom I continue to respect and admire, we're losing sight here of what the real reason for a jury view is. Certainly, there is value for this jury to appreciate the interrelationship of the dynamics of the Bundy and Rockingham crime scenes. Therefore, there was not so vocal an objection to there being a jury view. But, Your Honor, I don't think that there really is the need for the luxury of two jury views, given all the problems that have been discussed, given all the byplay that the various parties have offered, and given the evidence in this case. If the court will recall, the reason for a nighttime jury view, as I can recall, was to determine whether the only witnesses whom we are aware who were present at Bundy at or near the time of the crime were able to see something or not on the walkway. Clearly, Mr. Bostepi and Ms. Rasmussen have clarified the fact that they were able to see the body. That's not an issue. Clearly, Mr. Mandel and Ms. Aronson said that they did not see a body. But when you also remember the testimony, it was that once the barking of the dogs began, it continued. And there has been no testimony that I can recall from Mr. Mandel or Mr. Aronson that they heard the barking of the dogs at any time when they were walking by Bundy. So we are not being able to see the forest through the trees. What then is the practical benefit of a jury view at Bundy given this record? I think the evidence is clear that when a body was there, it could be seen. And arguably, when the bodies were not there, they were not seen. The dogs were not heard. They were not noticed. I am really concerned about the costs of this case, given the extraordinary nature of these proceedings and the cost of this jury view, given our belief that it is a luxury.
He doesn't care about the cost.
And I do appreciate the value of a jury view. Were there no pictures available at all that attempts to replicate the scene at night, I could better appreciate the worthiness of the arguments that are being made. But it is a luxury, Your Honor, not a necessity, and one that I don't think we need to go into right now, given where we are in the case, given the state of the record, and given the very serious problems about which there's still some question that are still unresolved. I am very concerned about the interrelationship of the moon and the fog, because we've been told that the fog enhances the brightness of the scene. And there wasn't fog, or we don't know if there'll be fog on August the 20th, when we are prepared to go. The court is well aware that the natural ambient dynamics in June differ in Southern California than in August. June is known for being foggy in the evening and foggy in the morning, and sometime around mid-morning the fog burns up and it's a beautiful day. That is not my understanding or my recollection. I've lived here all my life of the way that life is in August. August is cool all the time. So that's important. That's very important. And, Your Honor, if we are going to be out there, we should be out there and taking advantage of everything, not just what the people want, but also what the defense wants. We want to dispel the notion that one is incapable, and I dare say I anticipate the arguments from the aerial photographs, that Mr. Heitzler was incapable, standing 100 or so feet away, or 100 or so yards away, however the actual distance is, in the alleyway on the far side of Bundy, from even hearing what he suggests that he heard.
To grab the photo board, the aerial photo board that I believe Mr. Bailey took the photograph of.
His testimony, in many respects, is critical. His credibility, in many respects, is central to our theory that this man did not have the time to commit this crime, given their scenario, and given what Mr. Heitzler has testified that he's heard. Therefore, Your Honor, if we are going to go there, and I argue strongly that we should not, we should take advantage of the reasons that both sides want to go there. There is no need to go there to see if you can see a body, because the evidence is clear that you can. We argue, in fact, we will argue, that you can see a body if one is there. But if a body is not there, you cannot see a body. And we would offer the testimony of Mr. Mantell and Ms. Aronson to support that claim.
All right, for the record, Mr. Byrne has brought out, Mr. Byrne, what defense exhibit is that?
1239.
1239. All right, and this record should also reflect this is John Byrne, not his brother, Joe Byrne, who was also one of my law clerks.
Yes, Your Honor. Your Honor, their witnesses that testified about the dog barking, about how the barking continued for a half hour or more. Our witnesses were there within that window and heard no barking until 10:35 at the earliest, according to our witnesses. The record is clear. There is no necessity for a jury view. I am also concerned about the Malibu light because, as the court will recall, it wasn't simply not working, it was broken off. And as the court will recall, though it was supposed to be oriented to look at the numbers, it was not. It was tilted in an area towards the body and not away. And I am not comfortable with some hindsight speculation given 13 months or 15 months after the time to attempt to duplicate the precise angle of a central, close, and the closest light to the actual bodies. I am not comfortable with that at all, given where we are in this case, given the state of this record. I am not comfortable with that at all. The court will recall that Mr. Taylor and even the police officers, when we arrived, the first thing they said was that the lighting was different. And if they're not different, that's fine. But it doesn't remove or eliminate the serious concerns we have, given the costs, given the luxury of a second jury view, given the time that we've already spent on these issues, given the facts that are an issue. I think that is something the court has to really balance. What is an issue? It is not an issue that a body could be seen from the walkway at Bundy. That is not an issue. If, in fact, there is going to be a jury view, and there have been issues on both sides as to what occurred at different places at night, basic notions of fairness balance in favor of there also being a Rockingham view. Now, the court did a great job in preparing the parties for this view by, and I'm sure it's Mr. Burns, by culling for us a tremendously useful chart with specific references to the record as to what witnesses said about various lighting.
Actually, that was Ms. Carswell who did that.
And Ms. Carswell as well. The lighting, there was lighting over the garage of Mr. Simpson's house at Rockingham. There is no clarity at this point that it was the brighter light was there and the softer light was not, or which. And I think that, with all due respect, Mr. Hodgman is incorrect if he suggests that it was clear which light, because as the court will recall, Mrs. Baker and Mr. Baker, who were present at Rockingham, were unsure. I asked for Miss Gigi Guerin to be able to have the person who added the light disconnect that same light, but I don't know which one it is. And as the court will recall, we looked around over the garage and wherever to see if there's any other possible lighting. Clearly, there was the light there. As I told the court, all of Mr. Simpson's lights are powered by the same timing system. And therefore, it is reasonable to expect that at 10 o'clock at night on Sunday, June the 12th, all the lights on the system were all on. When police officers have testified that they were there, which was at or near daybreak of June the 13th, it's very clear and quite possible that those lights could have been off. And I was very curious how they were able to say quite plainly when we first got there that this light wasn't on or this light wasn't on, when as far as I can recall, they were never there at night to even know. As to the foliage issue, Mr. Hodgman, Detective Lang, and myself had occasion to walk down the Rockingham Walkway. And I'm sure Mr. Hodgman just simply forgot to tell the court that at the critical area where Cato Kalin heard the 3 thumps on the wall, the foliage that was there on last Sunday was substantially similar to the foliage that was there on June the 12th.
Let me ask you this, just as a practical matter. I recollect your request that we have the jurors go down that walkway, but it's also a rather treacherous walk, and especially if you want us to do it in pitch darkness back there.
This is what I would propose, Your Honor, that they be escorted in groups of 5, as they were earlier, that there be an officer or an escort with a flashlight in the beginning, perhaps one in the middle and one in the end, that they then be escorted by flashlight to an area, that on a particular sound signal, the flashlights all be cut off for 30 seconds, the jury not speak, but they could see, they can look, there's enough time for their eyes to be accustomed to the darkness there, and that they then be escorted out. That is an issue, I think, that is resolvable. However, Your Honor, that begs the question as far as the defense is concerned. There is no need, there is no manifest need, there is no legal necessity given the record to have any sort of a jury view at all. If a body is there, a body can be seen. That's what they're going to argue. We should be allowed to argue the converse. If a body is not there, and we know a body is not there because there were no barking dogs, the body was not seen. That's what a trial is all about. Sometimes, with all due respect, we get caught up in the hype, in all of the technology, in the majesty and the power of this particular case, with all due respect, because I'm part of it too. But what we lose sight of is this is a simple trial. I'm always reminded this is a murder case, pure and simple. Murder cases occur at night far too frequently in this dear city of ours. However, on every occasion, it does not justify a jury view given the state of the record. And given this record, Your Honor, that is an expense that the dear taxpayers of this city should not be forced to endure. I thank you.
Thank you, Mr. Douglas. All right, Mr. Hodgman, you have some brief comment?
No,
Yes,
sir.
Your Honor, and briefly, I'll agree.
All right, guys, we made it to the end. Thank you so much, Kelly. Thank you, thank you, thank you. All right, we're going to get into Mr. Hodgman again tomorrow. We're getting to the end, guys. We're getting close to the end of O.J. Simpson trial. Whew. Whew. All right, guys, have a good day. I'll see you again soon. Bye.